Welcome to California Bar Prep, your study companion for the California Bar exam. In this lesson, fees, trust accounting, competence, and duties beyond the client. Let's begin. Professional responsibility essays often move beyond loyalty and confidentiality into the mechanics of practice. Fee agreements, trust accounts, competence, candor to the tribunal, communication with represented persons, and fairness to third parties. These rules are highly testable because they create concrete lawyer duties. The lawyer either put client funds in trust or did not. The lawyer either disclosed a contingency fee in writing or did not. The lawyer either corrected false evidence or did not. California differs from the ABA in important places, so use a two-step rhythm. State the California rule, then compare the ABA rule when useful. Remember that discipline, civil liability, fee forfeiture, disqualification, contempt, and malpractice are different consequences. A bar essay usually asks what ethical violations occurred, not whether the client wins the underlying case. Fees generally. California fees must not be unconscionable. ABA fees must be reasonable. California Rule 1.5 lists factors for unconscionability, including amount of fee in proportion to value of services, relative sophistication, novelty and difficulty, skill required, likelihood that the employment precluded other employment, amount involved and results obtained, time limitations, nature and length of relationship, experience and ability, and whether the fee is fixed or contingent. Written fee agreements. California generally requires written fee contracts when it is reasonably foreseeable that total expense to the client, including attorney fees, will exceed the statutory threshold in Business and Professions Code Section 6148, subject to exceptions. Contingency fee agreements must be in writing and include required terms under Section 6147. Contingency fees. Contingency fees are prohibited in criminal cases and certain family law matters where payment depends on securing dissolution or amount of support or property division. They must not be unconscionable and must comply with writing requirements. Client funds. California Rule 1.15 requires lawyers to hold client or third-party funds in a client trust account, separate from the lawyer's own funds. The lawyer must promptly notify the client or third person of receipt, preserve funds, maintain records, render accountings, and promptly distribute undisputed funds. Competence. California Rule 1.1 prohibits intentional, reckless, grossly negligent, or repeated negligent failure to perform legal services with competence. Competence includes learning and skill, mental, emotional, and physical ability reasonably necessary, and diligence. A lawyer may acquire competence by association, consultation, or study. The trust account rule is one of the most concrete rules on the exam. Client money goes into trust. Lawyer money generally does not, except a limited amount necessary to pay bank charges. Unearned advance fees usually belong in trust until earned, unless a true retainer is involved and the rules permit different treatment after proper disclosure. Disputed funds. If the lawyer and client dispute part of the funds, the lawyer must keep the disputed portion in trust until resolved and promptly pay the undisputed portion. The lawyer may not hold all money hostage to pressure the client. Third-party claims. If a third party has a valid lien or a legal claim to funds, the lawyer may have duties to protect that interest. The lawyer should not simply follow the client's instruction to ignore a known valid claim. Analyze whether the third party has a legal interest, not merely a hope of payment. Commingling. Mixing client funds with personal or operating funds violates the trust account rules. Conversion or misappropriation is even more serious and can lead to severe discipline. Good intentions or poor bookkeeping do not excuse misuse. Note: a fee paid in advance is not automatically the lawyer's property. Characterize the payment: true retainer, flat fee, advance deposit, or cost advance. A lawyer need not begin as an expert in every field. The lawyer may become competent through reasonable preparation, study, or association with a competent lawyer. But the lawyer must not take on a matter and then neglect it, miss deadlines, or experiment at the client's expense. California's competence rule expressly includes repeated negligent failures, gross negligence, recklessness, and intentional failure. Missing one minor deadline may be malpractice or negligence depending on harm, but repeated missed deadlines and failure to communicate can become discipline. Diligence overlaps with communication. A lawyer must keep the client reasonably informed, respond to reasonable status inquiries, and explain matters enough for informed decisions. Settlement decisions belong to the client. Tactical decisions may be made by the lawyer after consultation, but major objectives remain the client's. Candor to tribunal. A lawyer must not knowingly make false statements of fact or law to a court, fail to correct false statements, or offer evidence the lawyer knows is false. If a client or witness offers material false evidence, the lawyer must take reasonable remedial measures. California and ABA rules both strongly protect tribunal integrity, though exact formulations differ. False testimony by criminal defendant. This is a sensitive area. The lawyer must protect the client's constitutional rights, but cannot knowingly present perjury. The lawyer should try to dissuade the client, consider withdrawal if possible, and follow applicable law and court procedures. Do not say the lawyer may simply let the client lie. Legal authority. A lawyer must disclose directly adverse legal authority in the controlling jurisdiction if not disclosed by opposing counsel. The lawyer may distinguish it, but may not hide it. Fairness to opposing party. A lawyer must not obstruct access to evidence, falsify evidence, counsel a witness to testify falsely, or make frivolous discovery objections. Paying reasonable witness expenses is allowed. Paying for testimony content is not. Communication with represented persons. A lawyer must not communicate directly about the subject of representation with a person the lawyer knows is represented in the matter, unless authorized by law or consent of that person's lawyer. For organizations, the rule may cover constituents whose acts or admissions can bind the organization or who supervise or regularly consult with counsel. Truthfulness to third parties. In representing a client, a lawyer must not knowingly make false statements of material fact or law to third persons. Negotiation allows some puffing, but not lies about material facts such as insurance limits, death of a client, or existence of key evidence. Putting advance fees directly into an operating account without analyzing whether they are earned. Treating a disputed fee as permission to keep all settlement proceeds. Only disputed funds stay in trust. Saying California fees must be reasonable. The California disciplinary standard is unconscionability, though reasonableness remains relevant in other contexts. Missing written fee agreement statutes. California frequently tests sections 6147 and 6148, allowing client perjury because of confidentiality. Candor and remedial duties must be analyzed. Contacting an opposing party directly because the lawyer thinks opposing counsel is slow. Consent or legal authorization is required. Paying a fact witness a bonus for favorable testimony. Reasonable expenses and compensation for time are different from buying testimony. Suppose lawyer receives settlement funds, deposits them into her operating account, pays office rent, and tells client she will distribute the balance after resolving a fee disagreement. This triggers multiple violations. Settlement funds belonging to the client or third parties must be placed in trust. Commingling and used for rent is improper and may be misappropriation. Lawyer must promptly notify, account, and distribute undisputed funds. Only the disputed fee portion may remain in trust. Suppose client tells lawyer he will testify falsely tomorrow. Lawyer must counsel against perjury and cannot knowingly offer false evidence. If necessary, lawyer must seek withdrawal or take reasonable remedial measures consistent with law. A strong answer separates duties to the client from duties to the court and states the likely ethical result without overclaiming. That's it for this lesson. Download California Bar Prep on the App Store for lessons on all 14 bar subjects, practice questions, and essay frameworks. Keep studying, and good luck on the bar exam.